Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. And I'm going to talk today once again about employee poaching and raiding. This is effectively part 2 of the employee poaching discussion. There are 2 entirely separate ballgames here, folks. One is hiring away individuals or teams of people who have non-compete agreements. I've talked about that before in a prior video discussion. That is a very tricky and perilous business, and there is a great deal of exposure there. I've already explained what sort of framework and analysis that requires. Today, part 2 of the discussion focuses on employee poaching and raiding where there are no non-compete agreements. So let's get into the mix. Some people might think to themselves, well, if there are no non-compete agreements in place, then I have absolutely no exposure for hiring away several people from a rival. And that is not always true. Sometimes there is exposure. The exposure is not as high as it would be in the context of a non-compete agreement, because there, if you have a non-compete agreement personally, then you have exposure for your own breach. And if others who you're hiring have non-compete agreements, you have exposure for tortious interference with contract or prospective economic advantage. So there's tremendous exposure in that ball game. In this ball game, there's still exposure, and it's not necessarily as clear-cut. It's a much more vague, nebulous, sort of squishy arena that you're dealing in, and so you have to be careful and you have to know what you're doing. Let's suppose you are looking to hire away a team of 7 or 8 employees from a rival. What is your potential exposure, absent non-compete agreements? Your potential exposure likely lies under 2 different legal theories. The first would be theft or misappropriation of trade secrets. The second would be some type of deceptive and unfair trade practices claim. Let's talk about the first, theft of trade secrets. If you are doing this in any industry that involves tech, that involves formulas, software, potential trade secrets, then you may have exposure for misappropriation. If you hire away a team of several individuals, all of whom are corporate insiders, scientists, programmers, etc., upper-level employees, there is a possibility that the plaintiff could accuse these folks of having trade secrets and then attempting to use those trade secrets in your new venture. That's your first sort of general predicate for potential exposure. Your second is even worse than trade secrets. Why? Because it is so much squishier and there are so few bright lines. Someone could potentially pursue a claim against you for a violation of a particular state's Unfair and Deceptive Trade Practices Act. In Florida, it's the Florida Deceptive and Unfair Trade Practices Act. Most states have something that is very comparable. The problem with this particular statute is that it is extremely broad, it's sweeping, it's vague, and it allows plaintiffs to seek a remedy for a wide range of conduct that could be considered unfair, immoral, inequitable. The problem with that, obviously, is there are no bright line rules. It's very hard to discern what constitutes good old cutthroat competition and what the court, as a matter of law, could construe as an unfair trade practice. So how do you avoid exposure under either of these different legal theories, under either misappropriation of trade secrets or violation of a deceptive and unfair trade practices statute? Well, there are a couple pointers that you can keep in mind. First, even though in this particular arena we are outside of the non-compete wheelhouse, number one, make damn sure there are no non-compete agreements. What do I mean by that? Well, you obviously want the employment agreements. You want any version of the employment agreement ever signed. You want any amendments to employment agreements, etc. Sometimes this is problematic because employees might not always have copies of everything they executed. So you want to get with the employee, you want to try and reconstruct their recollection of anything they signed. You want to get copies of anything that they have in their possession. And if they think they signed something else but don't have a copy of it, then you need to be extremely cautious because there's a good chance there's a non-compete in there. And even when you have all of the employment agreements, you need to look further than that. Say there's some type of stock agreement, some type of ERISA agreement, etc. There could be non-compete provisions buried in a wide range of different agreements. Not simply the employment agreement per se, but other ancillary agreements that were signed during the course of the employment relationship. So one, make damn sure there are no non-compete covenants in any agreements that were signed by the people you are attempting to hire. That's number one. Number two, with an eye toward trade secrets, if there are any potential trade secrets at play, you want to have your people who you're bringing in, you want to have them in writing enter some sort of safe harbor agreement with you. Basically, I use the term safe harbor, and we use this quite often in my practice on the consulting and advising side. If you're hiring away an individual or a number of individuals, and there's the prospect there that they may have trade secrets, you get them to sign something in writing saying they do not have trade secrets, they have not brought anything with them, you have not asked them to bring anything with them, they won't use anything from their former employment, they're being walled off in certain ways if it's necessary, etc., etc. So you get them to sign some sort of safe harbor agreement. That's number two. Number three, do not do anything shady. That's pretty self-explanatory, okay? Where people get themselves into trouble in this arena is when they do something that is simply objectively shady and stupid. And I'll give you an example, okay? You have company A, they're looking to hire away 10 employees from company B. Rather than simply doing it directly on the merits in their face, they decide to go about it in a shady sort of way. So they set up a shell company, company C, and they use company C to pretend like company C is interested in buying company B. And they get a whole bunch of inside information on company B. They find out who the big players are, who the real valuable employees are, who the real producers are, and then the fake deal between company C and company B goes south, falls through, never comes to fruition, but company C uses information and intel. Company C is really company A. They use information and intel that they gained during the course of those sort of negotiations in order to hire away the key people, the key players from company B. Let's say, just in this hypothetical, that there was no non-disclosure in place yet. They had some preliminary talks. They were going to sign an NDA. There was some information sort of proffered up front before an NDA was signed. So they can't get them on breach of an NDA. And fake company C, real company A, turns around and hires all the big producers away from company B. Okay? There's no breach of an NDA there, but the way in which that went down, setting up a phony company, using it to try and extract some important information about who they should hire, that's shady. You know? That's shady, and that could form the predicate right there for a raiding claim against you based on an unfair and deceptive trade practice. That's the sort of thing that you have to avoid. The sort of bottom line takeaway from all of this is that if you are going to hire away one person, you know, but particularly if you're going to hire away several people from a rival and there are no non-compete agreements at issue, cover your ass, make sure there are no non-compete agreements at issue, scrutinize every single document ever signed by any employee you want to hire, and make sure there are no non-compete agreements at issue. 2, use safe harbor agreements to try and cover yourself again. And then number 3, simply do everything above board. Be cutthroat, be competitive, go directly at the competitor, hire these people away, do it in the light of day, and don't do anything shady. Jonathan Pollard, non-compete, trade secrets, employee poaching and raiding attorney, downtown Fort Lauderdale, Florida. If you have a question or a concern about employee poaching or raiding or non-compete litigation, please feel free to give me a call. I would be happy to discuss it with you. Thanks for watching and have a good day.